Okay, so I have the Vernonia School District versus Acton. An official investigation led to the discovery that high school athletes in the Vernonia School District participated in illicit drug use. School officials became concerned that drug use increases the risk of sports-related injury. Therefore, the Vernonia School District of Oregon adopted the student-athlete drug policy, which authorizes random urinalysis drug testing of its student-athletes. And James Acton, a student, was denied participation in his school's football program when him and his parents refused for the drug testing, which raised the question, does random drug testing of high school athletes violate the reasonable search and seizure clause of the Fourth Amendment? Here's the Fourth Amendment. There should always be a warrant to search or seizure, and without it, it's not probable. James Acton was a 12-year-old and was not an accused drug user. He was a 7th grader at Washington Grade School when the school implemented the drug testing policy. James and his parents refused to sign a consent for the drug testing, and consequently he was not allowed to play football on his school's team because he refused to submit a urine sample for drug testing purposes. The Actons sought help from the American Civil Liberties Union. Since the Actons did not have the money to pay for an attorney, the ACLU gave them a list of attorneys who worked for free, and Thomas M. Christ was chosen by the Actons to help represent them. After the Actons appealed their case, they had to wait for the next round in court. Meanwhile, James Acton took the drug test in order for him to play basketball that winter, but still disagreed with it. The district court made 4 important findings of the fact. Drugs were present in Vernonia School District. School athletes were using drugs and playing sports unsafely under the influence. Athletes were role models in the rural community, and athletes were bragging about drug use to others. In court, the United States Court of Appeals in the Ninth Circuit reversed the trial court's ruling. They concluded that the school's drug use was unconstitutional. Afterwards, the school suspended their drug use program. The Actons brief gave the history of the case's facts. They agreed that the Ninth Circuit, when it stated that the evidence showed only some students to have been taking drugs, and it also stated legal arguments saying that the Fourth Amendment to the U.S. Constitution applies to them. They also stated that the search is unreasonable, saying that it invaded his privacy, and Actons believed that the school could find better resources to handle the drug testing. Both sides of the case appeared before the court in March. Vernonia School District was the first to present their arguments. There was hard evidence that there was a definite drug abuse in the school before it developed the drug test, and it was also mentioned if every school should have a random drug test or if schools should have the choice, which led to more questions. Was it necessary for non-athletes to be tested too, and was the consent form really needed? On June 26, 1995, the school learned that the Supreme Court had ruled in favor of the school district and was okay with drug testing. Justices agreed that the drug testing was not a violation of the Fourth Amendment, but the justices were split, however, on whether or not the drug testing that was used by Vernonia was a reasonable search under the Fourth Amendment. 3 justices didn't believe that it was. Justices O'Connor, Stevens, and Scalia did not agree with the majority. O'Connor wrote a separate opinion expressing only her views. She thought that since the teachers and coaches did not have first-hand knowledge of drug use, that there should not have been a drug test involved. And she finally concluded that it would have been more reasonable for the school to focus the drug test on students who are disrupting the classroom. She said it sweeps too broadly across the board.